Morning, everybody. This is Sam. I thought I'd start out today with a little bit of an education on, what kind of car washes we insure and the type of insurance coverages we offer, and then get into the best product for our clients and et cetera. But as you're all aware, that we insure many different car washes: self-service, express, flex car washes, full service with hand, full service with equipment, 24-hour C-store car washes, and the list just continues to go on. The type of coverages that we offer to all of our car washes is going to be property liability, employment practice liability insurance, GKLL, which is garage keepers legal liability, where you have care and custody of vehicles on your property. Pollution we offer as well, but that's basically for gas and sites of that type. And then workers' compensation, obviously, which is a statutory policy, the only policy you're required to have by law in the state of California. And then we offer as well cyber insurance for such things as corruption of data and things like that. But when you're going out and you're looking for the best product for your client, you're really looking at, as it is, workers' comp's a statutory policy. So you're trying to find the best carrier predicated on the type of car wash: full service with equipment, full service with hand, and you have to look at the smaller car washes and work with the carriers to see if they in fact are even willing to take on a small premium predicated on what their losses could be. A lot of carriers don't like to work with premiums less than $10,000. For those, a lot of times you end up going to the state fund and such. And also I look at to see when it's for the best product. How progressive are they with the return to work programs? Do they have a medical provider network? And that ties into with our advocacy with Jen as well, which we'll talk about here a little bit later on. And then looking at the mod, their mod requirements. Are they interested in high mods? Do they want a low mod? What mods are they interested in? And then once again, the price of premium is very important as well, but you have to look at when it comes to the best product, and some of these carriers have filed with the state where they can actually go in and produce a premium predicated on zip codes, so sort of almost like age banded when it comes to healthcare programs out there you can buy today. Our deal is trying to make sure that the programs, the claims management is provided by the carrier, and we're there to assist in the claims and make them move forward so that they don't get stagnated. And once again, we'll be talking with Jen as we get further into our webinar about the advocacy program. When you're looking at the best fit, we all know that carriers have a sweet spot. It's up to us as insurance brokers to find that sweet spot. Workers' comp, we've been working with these carriers that we're with, a lot of them for over 24 years, so they understand our business, and they actually have a trust in what we share with them because we know our business. We want to make sure that the carriers are friendly with the 8387 class code or any class codes associated with the car wash. We once again want to know if what they like in their mods, if that's the right fit. Additionally, we have exclusive programs out there where we actually have relationships with carriers because of the trust factor with us, that they'll actually just work with us on workers' comp and no other brokers. And then when you're talking about the best fit, you've got to be able to go in and explain every one of your insurers. You have to be able to explain to them the story of claims and what's happened out there. There's a lot of fraud, especially down in Southern California, the part of our state down in Southern Cal. So you got to be able to explain, where these claims have come from, who they are, do they still work there? It just goes on and on and on. And then lastly, you get into what we call the best price or being able to negotiate. And the best analogy I can give in this area is where you're actually looking at buying a vehicle. It's somewhat the same way in workers' compensation. You don't accept the first quote. You compare other quotes out there to get the lower quote for the insured, and you're looking for something that's fair but overly competitive as far as the quote's concerned. That's our duty to our clients. You don't want to have a client, after they buy workers' comp from you, you don't want them going out with post-purchase recognition, wondering if, in fact, did they make the right move in working with you and getting the right price. So being able to negotiate, you go back and forth, back and forth, back and forth, almost to where it becomes obnoxious, and the insurance carrier says, okay, I've had enough of you, Sam. Here you go. We're done. And that's where I like to get. And we always keep in mind the final decision is the prospective insureds and what they would like, where they would like to go. And we want to make sure that we, as our company at the Western Carwash Insurance Program, that we provide a sense of direction so that the confidence with our insured is with us, the carrier, and we continue to build our relationship into the future. And I think at this point, I'd like to give it over to Jen, which is a real reason you're all here today, is to talk about the advocacy when it comes to claims and claims management. And I will say that she's been somewhat of a godsend for our group, and I'm sure she's worked with many of you as well.
Thanks, Sam. As Sam mentioned, I'm a workers' compensation claims advocate with Alliant. As advocates, we help producers like Sam ensure that the claims are being handled by the carrier in a timely and effective manner, and also we monitor the financials at those crucial times of year, renewal and unit stat. And for those of you that aren't familiar with unit stat, this is when your claims are valued for your experience modification. I'm a former claims adjuster, and I was also an independent claims consultant prior to working for Alliant. So I have over 23 years of workers' compensation experience. And the bottom line is that we speak claims as advocates, and our goal is to work collaboratively with you and with your carrier for the best possible outcome after a claim is reported. So some of you may have heard of the term AOE-COE, and what this means is that in California an injury must arise out of and in the course of a person's employment. The burden of proof is on the employer and their carrier to prove an injury is not at least 1% caused by or aggravated by the employment. The only exception to what we refer to as the 1% rule is for stress claims or psychiatric injury claims, which have a 51% threshold, and for those, the burden of proof is on the employee. Some claims are questionable, and it's very important to understand that a carrier has only 90 days from the date that you, the employer, are aware of the injury so that they can investigate the claim for acceptance or denial. A claim that is not denied within that 90 days is presumed compensable, which means accepted. Claims can be accepted after that 90 days, but they can't be denied later unless there is new evidence that could have been discovered in that initial 90 days. Timely reporting of claims, especially questionable claims, is crucial, and I'll mention that 90 days to you again and again so get used to it. So there are three types of claims. A first aid claim is a minor one that doesn't require a prescription, time off work, work restrictions, or more than one follow-up visit with the occupational clinic. When in doubt, you can ask your occupational clinic if the case qualifies as first aid. And if it does, then you can arrange payment with the clinic directly. First aid claims should still be reported to your carrier as a notice only or a record only. If a carrier's claim report, or loss run is what we call it, has $0 paid because you have paid the bill, it will not impact your experience modification, but it's good for them to have a record of it. Another type of claim is a medical only. This refers to claims with treatment beyond first aid, but with no lost time from work. That includes modified duty claims where you are accommodating the work restrictions. And lastly, we have the indemnity claims. These are the lost time claims, the litigated claims, claims that require investigation into causation or subrogation, or that there are other issues that require a more experienced claim adjuster. There are also three types of injuries. The first is a straightforward, specific incident like a slip and fall, something that can be identified as caused by one incident or exposure. A cumulative trauma claim is something that develops over time or due to repetitive use. The date of injury for a cumulative trauma claim, or a CT claim is what we call them, is determined by the first date of disability or the date of the employee's knowledge that the injury is work-related. This could be the first medical visit or the first day off work, or something we see quite often is that their personal physician suggests their condition could have been caused by work, and then they report it. This is also the most common post-termination claim or post-resignation claim that we see. Any claim filed after employment has been separated should be reported to the carrier with a request for investigation. please recall the 1% causation or aggravation threshold that we discussed before. This means that although post-termination filing of a claim is a defense that can be raised, it is not a slam dunk denial that will be upheld. It often comes down to a medical determination. And sometimes concurrent or subsequent employers are joined to share in the cost of the claim. So it's important to give whatever information you have about that employee's experience to your carrier. The third is an aggravation of a pre-existing condition. This again requires that a doctor find at least 1% of a person's underlying medical condition was aggravated by their employment. The goal here is to get a person back to their pre-injury status. So these claims also need investigation often, and so that we can determine what their pre-aggravation or baseline status was. In California, permanent disability can be apportioned or reduced later when a person reaches that pre-injury or permanent and stationary status. If injury or aggravation is found, medical treatment and wage loss are paid in full and cannot be apportioned. Some claims are questionable or disputed and need to be investigated, as I mentioned. So I'll mention that 90 days here again because it's crucial to report all claims timely, especially if investigation is needed. A denial can be based on medical evidence, factual evidence, or an affirmative or statutory or legal defense. The California Labor Code has several statutory defenses. One of those I mentioned already is a post-termination claim. Another is a claim where intoxication was determined to be the proximate cause of the injury. And I want to mention here that there is a new OSHA rule on post-accident drug testing that, if you're not familiar with, should be looked into, or we can address that at a later time. But if an emergency room or another provider tells you that this person tested positive in the emergency room for, say, after a car accident for alcohol above the level, and that was the cause of the accident, then you need to let the carrier know right away so that that can be considered as a defense. Other defenses are self-inflicted or intentional injuries, altercations where the injured party is determined to be the initial physical aggressor, where the injury occurs during the commission of a felony, a psychiatric injury claim where it's reported after a good faith, lawful, non-discriminatory personnel action, or where the employee has not worked for, stress claims cannot be reported for an employee that worked less than 6 months. There are exceptions to these defenses, but when in doubt, ask your carrier to investigate, ask Sam and I questions. If a claim is denied, an employee's recourse is to request a panel qualified medical evaluation, or a PQME, to dispute the denial. This makes sense for medical-based denials. For factual or legal denials, the medical evaluation may still be necessary to determine the extent or the cause of an injury or medical condition, but the factual or legal issue that resulted in a denial is still a factor. During the 90 days of investigation, an employee is eligible for medical treatment up to $10,000 or until the claim is denied. That treatment must be requested by an approved medical provider, and all treatment requests must also go through the utilization review process. This means that treatment must be considered medically necessary and related to the claim in order to be approved. Even if you are questioning the claim, you should refer the employee to your designated occupational clinic for treatment. The investigation does not have to take 90 days, especially if there's a factual or legal basis to deny the claim. So the quicker the denial, the less of that $10,000 that will be paid in treatment. I recommend that you stay involved after reporting the claim. Ask your carrier for updates on their investigation progress. Provide witness names or any other information the carrier needs so that they can investigate timely and keep things moving. So cost savings opportunities. What can you do as an employer to keep your costs down on your workers' compensation claims? Reporting all claims timely and referring employees for treatment at your designated occupational clinic right away can help reduce your litigated claims, as well as lost time and lien exposure. Not all claims should be disputed, and providing timely medical treatment can often lessen the duration a claim is open, as well as reduce litigation costs because the employee feels taken care of. Medical liens should be avoided. They're generally the result of an employee getting an attorney who refers them to a non-approved provider who will treat them regardless of whether that treatment is approved or not. These liens are usually settled for a reduced value, but if there are many liens, they can quickly add dollars to a claim, and those dollars impact your ex-mod. Disputed or questionable claims should also be reported timely. Again, just 90 days to investigate, and I recommend you stay involved with the carrier during that 90 days and after. A return to work program can also reduce the overall cost of claims. Your designated occupational clinic should be aware of the jobs your employees do so that they can properly address work restrictions. I suggest providing job descriptions to your occupational clinic and to your carrier. I know that providing modified duty can at times be difficult. Some carriers are now offering a nonprofit organization alternative. If you can't accommodate the work restrictions, ask your carrier if the nonprofit option is one they can assist with. Or get creative. Maybe someone can sit and fold towels or do some other task that you didn't think of as modified duty. Anything to reduce the temporary total disability or TTD exposure and overall claim costs should be explored. That includes offering part-time work if that's all you have available, and the carrier will make up the difference. Offering modified duty can also reduce litigation. It helps to not have your employees at home sleeping in and watching all those attorney commercials. Alliant Claims Advocacy can also help. Let Sam and his team know if there are questions or concerns about a claim early on so that we can help you navigate the investigation process or just the claim process in general. We, as I said before, we speak the language of the carrier and the claim adjuster and can help keep the claim moving. Yeah.
Many times when you guys have a workers' comp claim out there, we are not notified by the carrier, so we don't know there's a claim out there, and then all of a sudden it goes on 6 months and it's gotten a little bit in a disarray. Please feel free to let us know you've got a comp claim out there so we can get our advocacy, get Jen involved as soon as possible.
Thanks, Sam. So the last slide here is regarding the 2017 experience modification. I've mentioned the XMOD a couple times, so I just wanted to also mention that effective 1/1/17, the way that XMODs are calculated in California has changed. This is the first formula change since 2010. And without getting too technical, individual employers' payroll is now considered along with the class codes, and it's now called a variable split point instead of a fixed split. That fixed split used to be $7,000, and now it varies based on payroll anywhere between $4,500 and $75,000. So the message from the WCIRB, the entity that publishes your XMODs, is that an employer's focus should be on loss prevention and reducing the frequency of claims. So I appreciate everybody's time, and Sam does, I'm sure, as well. And we'll now take questions if there are any. Let's see, Larry asked if there are handouts, and there were not handouts. But this webinar will be recorded, and you can provide the slides if anyone needs those.
Yeah, I'll make sure that you get the slides, Larry.
Are there any other questions?
Once again, please keep in mind that when it comes to workers' comp, that I want to reiterate this, that we will not know anything because the provider does not call us. And the workers' comp is completely different for the most part than your property liability, where there is, on the property liability, when there's an injury or to a customer or damage to a vehicle, it's pretty much cut and dry. But when it comes to workers' compensation, these things can go on, Jen, for years. They've got a long tail. So anyways, we appreciate your time, and if you want to, I'll make sure that everybody on this call today gets a copy of these slides. Thank you so much.
Everybody have a good weekend.